So, Petrean's honoured guests, ladies and gentlemen, it gives me great pleasure to introduce our guest for this first inaugural lecture in honour of our long-time and distinguished fellow and now emeritus fellow of the college, Dr. Roderick Mondet. And we're extremely fortunate in our speaker tonight. Not only is he a Petrean, but he's a specialist in an area which in these Brexit-laden days couldn't be more relevant. Michael Dougan is Professor of European Law and the Jean Monnet Chair of EU Law at the University of Liverpool. He specialises particularly in EU constitutional law, EU welfare law, and the single market. So, his work on the EU constitution and institutions covers constitutional reform and the relationship between union laws and national legal systems. He's written extensively on single market law, and especially the free movement of goods, persons and services, and the processes of harmonisation of member state laws. And his research is focused on the interaction between free movement rights and social security entitlement. You couldn't wish for a better list of things to focus on in these times, in a week dominated by reports on Brussels of the ups and downs and the ins and outs of the latest European summit, and the question of whether a Brexit deal between this British government and the European Union is achievable in the time available, and the choice, what choice of lecturer could we have that would be more topical for all of this? Moreover, Michael has appeared as an expert witness before committees of both the House of Commons and House of Lords. He's acted as an external advisor to the government on EU matters, including the all-important matter of Britain withdrawing from the European Union, and he's working on a monograph of the OUP entitled "The UK Out With," not without, out with the EU, and the EU without the UK. So, for a lecture devoted to a legal theme, we couldn't ask for anything more to share his expertise and assessment of where we might be heading. Can I ask you all to join me in welcoming him to Peterhouse? Thank you.
Thanks very much to the Master for the really kind introduction, and of course thank you very much indeed to Peterhouse for the invitation to come here to deliver the inaugural law lecture in honour of Dr. Mondet. I still find it very difficult to call him Roderick. He's still Dr. Mondet, but it's an enormous honour and a pleasure. And one of the things I was thinking as I was travelling down from Liverpool is that I expect Roderick, when he looks across this room, and generations actually of Peterhouse lawyers pursuing their careers, pursuing their lives, must feel very, very proud. And conversely, certainly for myself, but I suspect for a great many other of the people in this room as well, being here tonight I think is a really wonderful chance to honour and thank Roderick for the opportunities that he's given me, and in fact that he's given a great many of us. Those of us who work in university life, university admissions, sitting on recruitment panels and so on, we know that for what for us is the relatively small decision of who to take into your college, who to employ under your staff, they're relatively small decisions for us, but they can have the most profound and the most long-lasting consequences for the lucky person who's on the receiving end of that relatively small decision. And many of us were the beneficiaries of those relatively small, but nevertheless expert, careful, and considered decisions taken by Roderick and by his colleagues. They saw our potential, they saw our strengths, and they offered us the chance to fulfill that potential and to pursue those strengths in such a privileged educational and intellectual environment. We've been able to go out into the world to become lawyers, to become civil servants, to become educators, to become actors as well, of course, and it's profoundly and permanently changed us through the opportunities that Peterhouse and Roderick gave us. And I suppose for me that's probably the quality that I remember most about Roderick and that I feel most grateful for when I think about the 10 years or so actually of my life that I spent in Cambridge, which all started with a little interview with Roderick to the spotty, geeky, nervy, rough little 18-year-old me. And it was his commitment to meritocracy and his willingness to put that commitment into practice so that talented young men, talented young women who weren't necessarily lucky enough to be born into a world of easier opportunity could nevertheless work hard and recreate some of that opportunity for themselves. And I know certainly in my own role, in my own institution, where we have a lot of students who come from very difficult and disadvantaged backgrounds, that's probably the main lesson that I've taken from my time at Cambridge, at Peterhouse, and indeed from Roderick, is to make sure that I bring those core values of meritocracy and fairness into my job. So, an enormous honour, an enormous pleasure, and enormous thanks to Roderick. Now, I'll move on then to the subject of my lecture. I'm not actually going to say anything, for example, about the referendum, either its background, its conduct, its outcome. There's a lot to say, of course, and if we have time for questions, I'm perfectly happy to let you know my thoughts on them. But the focus of this lecture is really rather different. I'm going to be talking about the challenges which are currently confronting the UK as we prepare to leave the EU. Now, even here, even on this subject, we have to be highly selective because the challenges are myriad. In fact, they are mind-boggling. We have, as the Master indicated, the current withdrawal negotiations between the UK and the EU. They cover an unbelievable array of divorce questions, from the big ones like the current status of EU migrants, the Northern Irish border, through to what do we do with existing contracts for the supply of nuclear materials, how do we handle pending applications for intellectual property protection, what do we do with the storage and handling of personal data, ... The list really is quite endless. And that's before we've even started to think about our future relationship with the EU and its member states, ranging from trade and the environment through to police, anti-terrorism, defence cooperation. And I have to say, only a particular species of cretin would ever really believe, or ever could believe, that these negotiations were going to be the easiest in human history. Like most international negotiations, these are going to be extremely difficult, technically complex, and politically sensitive. And then there's the small matter of our relations with the rest of the world. We need to regularise our membership of the WTO. We started that process just a few days ago. It's already run into significant problems as our friends across the Atlantic almost immediately objected to our proposals. We need to sort out our precise relationship with the EU's existing international agreements. There are around 1,150 of them with third countries and international organisations. For every single one, we have to work out individually what our relationship to it will be in the future. And all of that's before we even start to try and create new relationships in trade, in the environment, in security and defence and so on. So we have major external challenges, but in some respects, even those questions fade in significance, or at least in urgency, compared to the internal challenges which leaving the EU poses for the UK, and especially of extraordinary interest for us, to our legal system. Because for over 40 years, the UK legal system has evolved under the influence of and combination with EU law, and withdrawal without adequate preparation would risk, to put it bluntly, creating a state of legal chaos and administrative malfunction across the country. And making those preparations is the primary purpose of the European Union Withdrawal Bill, which is currently making its way through Parliament. Now, bless you. In order to explain better the nature of this withdrawal problem and also the nature of the government's proposed solution, it's useful for us to recall some of the basic principles that govern the domestic status of EU law within the UK. These are principles which will be familiar to law students up and down the country, but since some of us maybe studied law 20 or more years ago, it maybe is useful just to recapitulate them briefly here. The domestic status of EU law is still governed primarily by the European Communities Act of 1972. And there are really four key points that we should highlight for the discussion that we're going to have shortly. First of all, the ECA provides a legal basis for the government to implement EU measures, mostly directives, into UK law by means of delegated legislation. Now, EU measures can be implemented into UK law by other means, by primary legislation, by delegated measures under other acts, but the ECA is the most important legal basis for the implementation of EU measures into the UK legal system. Secondly, the ECA doesn't just provide for implementation of EU measures, it also grants statutory recognition for the enforcement of other, what we call directly effective EU measures within the UK. That includes, for example, the broad category of EU regulations, one of the main legal instruments through which the EU legislates and conducts its administrative activities. But it also includes certain treaty provisions, for example, the right to equal pay between men and women, the provisions on free movement, and so on. And it also includes the provisions of directives themselves where they have been misimplemented by the member state, where implementation is proven to be defective. Individuals can choose to rely directly on the misimplemented directive and to bypass the faulty national implementation measures. Thirdly, the ECA incorporated the infamous principle of supremacy into UK law. If there is a conflict between directly effective EU law and a provision of purely domestic law, the national court should give priority to the EU measure by disapplying in practice the purely domestic one. And that's true in the UK, even if the purely domestic measure is primary legislation that was adopted after the 1972 Act. Now, as the House of Lords clarified in the Factor Term case, as Parliament itself explicitly confirmed in the European Union Act 2011, the UK courts give effect to the supremacy of EU law only because Parliament has told them to. And if Parliament were ever to tell them otherwise, the UK courts would obey Parliament. Fourthly and finally, the provisions of the ECA also provide the basis for the legal reception into the UK legal system of what we call the other structural principles of EU law. These are the principles which seek to govern the way that EU law is handled by the national courts in practice. So, for example, one of the main structural principles is the duty of interpretation, that in order to avoid a conflict of law, you should try to avoid national law and EU law openly conflicting with each other. You should use methods of interpretation, if you possibly can, so as to make national law fit with the member states' treaty obligations and therefore avoid a conflict of law. Now, that is our system for incorporating EU law into the UK. We domestically implement a lot of EU law through primary and secondary legislation. We recognise the direct effect of a lot of EU law simply because it exists and our national implementation was either unnecessary or defective. And we have a set of legal principles which tell the courts how to handle and how to enforce EU rights and obligations. Now, that system begs some fairly obvious follow-up questions. We may well have a process for incorporating all of this EU law into the national legal system, but just how much EU law is there, and just how important or influential is it? Now, here there is an understandable but really very unfortunate tendency, especially among non-lawyers, to want a number. They want a simple number. Tell us the percentage of law that comes from the EU. Tell us the statistics. And certainly that tendency was played upon during the referendum campaign, particularly by the Leave camp. They repeatedly produced various numbers which tried to demonstrate that the proportion of UK law that derived from the EU was entirely enormous, leaving our own Parliament marginal and disempowered as the sort of faceless, unelected bureaucrats in Brussels came to dominate national life. So, for example, UKIP repeatedly asserted that Brussels makes 75% of all UK law is made in Brussels. They were unable, of course, to provide any basis for that claim other than some unsubstantiated, off-the-cuff press remarks from a former EU commissioner. Appearing before the House of Commons Treasury Committee in March 2016, Boris Johnson cited what he called new evidence that put the true number at 60%. 60% of all UK law is imposed by the EU. Upon the flimsiest of further analysis, this turned out to be a gross misrepresentation of some actually quite dated House of Commons library research, but of course it didn't stop Boris Johnson from repeating it over and over again during the referendum campaign. But probably the most important and the most influential backing for the Leave claims about the extent of EU law's influence within the UK came from the campaign group Business for Britain. In March 2015, they produced a report entitled The EU's Influence Over British Law, The Definitive Answer. It was replete with methodological explanation, scientific formulae, lots of detailed numbers. It was written by a complete non-lawyer, and it was funded by a charity that was under investigation for allegedly breaching the rules on political bias. But nevertheless, it decreed that between 1993 and 2014, 64.7% of all UK law was influenced by the EU, and that included 59.3% of all UK law imposed by EU regulations. So nearly 60% of all UK law made up of EU regulations. Now, I was actually asked to produce a detailed analysis of this report for the academic journal Radical Statistics. It's due to be published any day soon, but if anyone's interested, you can drop me an email and I'll send you through the paper. Among many other things, I found that the Business for Britain methodology usually had the effect in any given sample month of multiplying the number of relevant EU measures by a factor of between 10 and 14. Now, for a self-proclaimed definitive answer, I'd have thought that a margin of error of 2 to 4% would be pretty disastrous, but to have multiplied your numbers by 10 or 12 or 14 is simply called lying. Now, none of that is particularly surprising. But more important, I think, for present purposes is the point that no competent lawyer would set out to undertake a task like that. Because we know that it's extremely difficult, if not simply impossible, to say anything meaningful about the relationship between two legal systems, such as the UK and the EU, using figures and percentages. These are questions which are only really amenable to qualitative analysis, and in that regard, we can offer some fairly straightforward propositions about the way that EU law impacts upon the national legal systems. Because, surprise, surprise, of course, this is what an entire discipline of academic researchers do for a living. For example, we know that the impact of EU law varies greatly across different policy sectors. In some fields, such as customs or competition law, EU law has a powerful or even a dominant influence. At the other extreme, there are fields such as taxation or healthcare, education, social security, criminal law, where the impact of EU law is limited or even marginal. And in between, there are a whole range of fields where EU law makes an important, but usually an ad hoc, sort of patchwork quilt impact upon the national legal system, certainly falling far short of a comprehensive legislative code. For example, single market regulation, consumer rights, or environmental protection. Moreover, many EU measures tend to set out general objectives or principles, and it's up to the member states to translate those objectives or principles into more concrete rules, rights, and obligations, so that the framework may well be European, but all of the key tools and instruments are national. Moreover, we know from extensive research that in the process of translating EU law into national law, many member states decide to gold plate, as the phrase goes, basic EU legislation. They extend its scope of application, they add in extra rights or obligations, they create more detailed frameworks and processes. And of course, we know that many EU measures are based on offering member states various derogations and exclusions and opt-outs, and that applies even to the entire policy fields. We all know the UK and the single market being the main example. Now, when you put all of this qualitative analysis together, the result is that the relationship between EU and national law is so complex, it's so intertwined, that it's simply difficult often to tell where the national starts and where the European stops. And in many situations, trying to describe the national and divide it from the European is like trying to take the milk out of the tea, or trying to do the job of a philosopher rather than a lawyer or a civil servant. And so the net result is really the main point that we want to make. It's precisely because of this highly intertwined relationship between EU and national law that UK withdrawal poses two major internal challenges. And the first challenge is to leave the EU while protecting legal certainty and legal continuity through the very act of leaving the EU. Because if we were simply to walk out of the EU tomorrow, the internal consequences for our own society, for our own economy, would be calamitous, and I'm not using that word lightly. Large patches, indeed entire sectors of regulation, would simply disappear, because huge numbers of domestic implementing acts, as well as directly effective regulations and treaty provisions, which regulate our conduct, which regulate the powers of our public authorities, would no longer have any legal basis within the UK. At the same time, right across the country, a wide range of existing legislative frameworks might not disappear, but they'd be rendered unworkable or even nonsensical. For example, it would no longer be possible to identify a competent decision maker, or the flow of vital information that actually makes public authorities capable of doing their jobs would dry up. And as a direct result, vast numbers of both public and private relationships would immediately and without notice become subject to entirely different rules, if we were even able to work out what rules there were at all. Now, in a way, for me, I suppose, the only thing more shocking than the idea that any developed country would even place itself at risk of such chaos and dislocation is the fact that so many of our politicians are so fanatically hostile to the EU that either they do not believe this to be true, or worse still, they believe it to be a price worth paying for, in their mind, escaping the evil empire of the EUSSR. But we really do have to make the point very, very clear. Regardless of how you voted in the referendum, regardless of what you think about leaving the EU, this is an incredibly important challenge. It is not a figment of the imagination, and it needs to be addressed, and addressed properly. So that's our first main challenge: safeguard legal certainty and continuity through the very process of leaving the EU. Our second main challenge is more for the medium and long term. We have to embark upon the unprecedented process of de-Europeanising our national legal system, of undoing 40-odd years of legal co-evolution. Now, on one level, a relatively superficial level, the one which is usually presented to us by the government, de-Europeanisation is simply about taking back control. We allow Parliament, we allow the devolved legislatures to make their own substantive decisions about which aspects of our EU legal heritage we want to retain, which we want to amend, and if so, how, which we want to replace, and if so, with what. But at a much deeper level, de-Europeanisation raises some really quite profound problems and challenges for us as a country. For example, the cross-border problems of trade, of pollution, of crime, of terrorism, which it is the primary purpose of the EU to help its member states address, are not going to disappear just because we are leaving the EU. Those problems are still going to persist. It's just that we're going to have to find solutions to those problems on our own. And so withdrawal poses the important question: how will this affect the capacity of the UK state to find effective solutions to inherently cross-border problems that will continue to threaten our population? Or again, what will happen when we remove the regulatory safety nets, which were agreed at the EU level so as to provide minimum standards of protection for the environment, for workers and for consumers? Now, we know that many of the leading Leave campaigners, what they would like to see happen, they call it a once-in-a-lifetime opportunity to have a giant bonfire of Brussels red tape. But such extreme views are not limited to the hard right. The government itself has repeatedly threatened that after withdrawal, the UK could choose to abandon, and I'm quoting here, abandon the European economic and social model of welfare capitalism and define itself instead through a model of low regulation, low tax and low public services. In other words, it should be crystal clear in the medium to long term that leaving the EU isn't really just about leaving the EU. It's about entirely transforming the nature of our national legal system, and with it our economy, our society, our political life, based upon prizing open the sort of constitutional space that's required by those with a radical agenda, be it on the left or on the right, who want to fundamentally redefine the contract between citizen and state. So we have two major internal challenges. There are other internal challenges, of course. I'm not even going to mention Scotland, Wales and Northern Ireland, let alone the future of English governance. One lecture is certainly not long enough to deal with those. But the question is, how are we going to deal at least with these two challenges? Now, the government strategy was sketched out first in its white paper from February 2017, and then described in greater detail in March 2017 in the white paper on the so-called Great Repeal Bill. It's now assumed concrete draft legislative form in the European Union Withdrawal Bill that was published on the 13th of July 2017 and is currently making its way through Parliament. With a view to enactment, the government had hoped by early in the new year. That hope is beginning to look a little overly optimistic. Now, the bill has already been the subject of intense criticism. MPs have proposed several hundred amendments. The governments of Scotland and Wales have already indicated that they are not willing to grant their legislative consent for the bill in its current form. And the government is clearly on the back foot here. A debate was scheduled for the bill in Parliament this week. It is being postponed until an unidentified later date. So we can safely assume that the final legislation will emerge, if at all, in a heavily amended form. But for now, all we have to work with are the government proposals, and of course that's good enough because it represents the government's official starting point, and it's the only basis on which to understand why so many parliamentarians and why so many other citizens are concerned and criticise this bill. Now, the government's basic strategy runs as follows. Let's deal now with the immediate challenge of protecting continuity and certainty. We'll worry about the longer-term process of de-Europeanisation at some stage in the future, in the years, in the decades to come. And the immediate objective of safeguarding legal continuity, legal certainty, is best served by EU law simply remaining part of the UK legal system wherever practical and appropriate. We'll keep all of those EU measures, such as directives that have already been implemented into the UK. We'll incorporate all of those EU measures, such as regulations, where we currently rely on the principle of direct effect. But at the same time, there needs to be an extensive programme of secondary legislation adopted by the government with parliamentary oversight so as to make changes to all of that EU-derived law where it would no longer function sensibly, I'm using the technical terminology of the government, it would no longer function sensibly outside the EU. But any significant policy changes the government has promised would be undertaken by Parliament acting through primary legislation, not by the government using delegated powers. And it's certainly clear, as the government itself recognises, that in some sectors, such as customs or agriculture or immigration, we can't simply retain EU law, we can't just amend it, we actually have to completely redesign and implement a new policy and regulatory framework. Now that's the government's outlined strategy, and in principle, it's both simple and sensible. But let's be clear, the EU Withdrawal Bill is probably the most important piece of constitutional legislation to be presented to Parliament, certainly since 1972, if not for considerably longer. And it raises some very difficult, if not altogether troubling questions, not least about the nature and functioning of our democracy. For example, the government says that existing EU law should generally be retained. But it's also clear that not all EU law will be retained, so what are we keeping and what are we rejecting, and according to which criteria? Or again, the government wants the power to amend retained EU law so that it's still capable of functioning sensibly outside the EU. Well, how do we define the government's delegated powers in a way which is adequate to do the job, but without creating more far-reaching discretionary powers that would simply allow the government to use the process of leaving the EU so as to enact subjective policy changes as regards measures that they simply don't like? How do we identify those policy decisions, which even if they are about leaving the EU, they're inherently linked to the process of withdrawal, they're nevertheless sufficiently important, they're sufficiently significant that they should be done, as the government has promised, directly by Parliament, not through executive action? And of course, the biggest question of the lot, how do we design a system for the operational scrutiny and control by Parliament of the government's enormous proposed delegated powers? Now, we're going to explore those questions in the rest of this lecture, but as I keep telling my PhD students, legal research is not murder mystery writing. You do not save the conclusion to the end and keep people guessing. You tell them what the conclusion is first and then substantiate it. So I'll tell you the conclusion right now. A wide range of potentially highly significant policy changes capable of going far beyond those which are necessitated by the very act of withdrawal fall within the exceptional scope of the powers proposed under this bill, and they will be subject to only limited, if not altogether marginal, parliamentary scrutiny and control. Under the government's proposals, the price of preventing our country from falling into a state of legal chaos and administrative malfunction is that we suspend our belief in the centrality of parliamentary democracy, and we place considerable faith instead in the capacity for self-restraint of massive executive power. So, I'll explain and justify and substantiate those claims. And let's begin with the basic scheme setting out the retention of EU law within the UK, which is dealt with under clauses 2 to 6 of the bill. Now, as the government promised, existing domestic implementing measures, such as directives, are to be preserved. Other EU measures, such as regulations, are to be incorporated. Other EU rights, such as the directly effective treaty rights to equal pay and so on, will also be retained. But the government has made certain clear policy choices about what it does not want to keep. Now, I'll just give one example, and it's the most high-profile example, the Charter of Fundamental Rights. Now, the EU's written Bill of Rights, the Charter, is primarily directed towards controlling the actions of the EU itself. But it's also capable of applying to the member states, as the phrase goes, where they act within the scope of union law. For example, if a member state is implementing a directive, it's acting within the scope of union law. It can be judicially reviewed against the Charter. As such, there's no doubt whatsoever that the Charter forms part of the existing corpus of EU law, which has legal operability within the UK. Nevertheless, the government says we're not keeping the Charter, and it gives two reasons to justify this. And the first is that keeping the Charter makes no sense because the UK can no longer be acting within the scope of EU law if it's no longer a member state. Now, this is a very weak argument. After all, the bill explicitly defines the scope of EU law as it is retained within the UK legal system, so the bill itself gives us a definition of the scope of EU law for the purposes of the UK legal system. But just as importantly, the government is happy to keep other parts of EU law which depend on exactly the same test. For example, the general principles of EU law, our system of judicial review. They also rely on a test of acting within the scope of EU law. If that test can work for one group of law, it can work for the other groups of law that use exactly the same test. The government's second reason is that non-retention of the Charter doesn't really matter anyway, because everything that's in the Charter is already in other EU, ECHR or domestic human rights protection. And in fact, David Davies stood up in Parliament when introducing the bill and challenged anyone to produce a single example of where non-retention of the Charter would actually change the law at all. I'll give him an example. And the case is called Watson, actually previously known as Watson and Davies. Tom Watson, MP of the Labour Party, David Davies, MP of the Conservative Party, brought an action for judicial review challenging UK legislation on the generalised retention of data for users of electronic communications and granting wide rights of access to that data to various national authorities. Now, Tom Watson and David Davies relied for their action for judicial review against the UK on the EU Directive on Privacy and Electronic Communications in combination with the Charter of Fundamental Rights, and specifically Article 8 of the Charter on the right to data protection. And as the Court of Justice affirmed when the court upheld the action by Tom Watson and David Davies, Article 8 of the Charter is a distinct right which has no equivalent in other human rights instruments such as the ECHR or the Human Rights Act. Moreover, as the court recently affirmed in Opinion 115, Article 8 has no equivalent in other parts of EU law because it goes further in defining the conditions for lawful or unlawful data retention and protection than any other provisions of the treaty. So there's our example. The rejection of Article 8 of the Charter will lead to an appreciable lowering of judicial protection of the right to data protection for individual citizens as compared to the safeguards provided under other provisions of EU law, under the ECHR or under the UK Human Rights Act. And the very man who helped demonstrate this fact and gave us the example he wanted is the very man who stood up in Parliament and said that it didn't exist. You really couldn't make these things up. But of course the government knows this. Let's not pretend. The government knows this. The rejection of the Charter is a political choice. It's not motivated by concerns about whether it's technically operable. It's not motivated by concerns about whether citizens' rights are adequately protected. It's motivated by the seething contempt in which the Charter is held by ideological Eurosceptics. So we have certain policy choices made by the government about which provisions of the Charter to keep, which provisions of EU law to keep, and which to reject. There are other problems with the drafting and with the system by which the government proposes that we should retain or reject EU law. I won't go into them in any detail here, but if anyone's interested in the examples, you can either ask me or I can email them to you separately. But let's move on to our next not-so-murder mystery question. Under the bill, the government is requesting a wide range of delegated powers from Parliament, and the list is quite extensive, far more than we have time to explore here, but there are three key powers which are central to the government's strategy under the bill. The first is to provide for the timely incorporation into UK law of the detailed terms of any withdrawal agreement between the UK and the EU reached under Article 50 of the TEU. That assumes, of course, that Parliament separately approves that agreement. This is a power to implement it, Clause 9. Secondly, there's the power to make provision for any situation where withdrawal from the EU could lead to the UK breaching other international obligations, Clause 8. Thirdly, and most importantly, there's the power to adopt a programme of amendments that will ensure that retained EU law is still capable of functioning in an effective and coherent manner after we leave, Clause 7. Now, I'm going to concentrate my comments on Clause 7, but many of these comments, I suppose you'll have to take my word for it, would be equally applicable also to the other delegated powers in the bill. Now, the abstract nature of the problem that Clause 7 seeks to address is reasonably clear. We need to identify and we need to respond to the particularities of EU law as it would apply to a non-member state. EU law is designed to be used by member states of the EU. We are proposing to use it as a non-member state of the EU. And so to ensure that we genuinely serve the goal of legal certainty, legal continuity, we actually have to make sure that all of this retained EU law functions properly. For example, many EU measures seek to regulate cross-border situations. They create systems of cooperation between national authorities across the member states. And so a wide range of domestic decision makers participate in these pan-European networks aimed at, for example, generating, exchanging and sharing information, at apportioning jurisdiction or responsibility to tackle particular categories of dispute or problem, to provide for mutual recognition and enforcement of each other's decisions, and so on. And these networks, these pan-European networks, are embedded and operational right across the entire legal system. We just take them for granted. They cover everything from toy safety alerts through to the protection of intellectual property rights, participation in emissions trading schemes, cross-border social security payments, transnational police and security cooperation. In each and every single case, we will have to decide, can those EU rules make any sense? Do they serve any useful purpose when you're no longer part of the pan-European network of cooperation that they're meant to serve? And if not, what do we replace them with? What alternative arrangements do we need to construct in order to tackle the relevant regulatory challenges and problems? Because the challenges and problems aren't going anywhere, only the tools that we currently have to tackle them. Similarly, many EU provisions confer decision-making powers directly upon a range of EU institutions, bodies and agencies, again across a huge variety of policy fields. It covers anti-dumping duties against cheap third-country imports, the safe regulation, marketing and use of products like medicines and chemicals, the freezing of assets held by third countries or individuals suspected of supporting terrorism, etc., etc., etc. And again, it's going to be necessary for the UK in each and every situation to decide, do we just continue letting the EU make these decisions for us? Do we just let them do it and we will swallow the consequences? And if not, who are we going to appoint as our national decision maker in their place? Who will decide? What powers will they have? Who will they be accountable to? And such questions, in any situation where you're creating a new set of public bodies and public powers, go far beyond the purely technical or the purely mechanic. They involve fundamental questions about regulatory power and capacity, about expertise and resources, about governance and accountability. They go to the very heart of democracy. Now, there are hundreds upon hundreds upon hundreds of such situations. All of them need to be addressed, preferably before withdrawal, so as to make sure that retained EU law is actually capable of functioning effectively and coherently when we leave. Now, being realistic, this is clearly not a job for Parliament. The sheer scale, the complexity, is beyond the capacity of Parliament to deliver within the limited time available. So this job must be done primarily by the government using delegated powers. And it should be obvious, I think, even from the few examples that I provided, that the government's powers cannot be limited to purely technical or mechanical changes. They do have to involve important policy choices. Yet surely we don't want to hand the government the power so discretionary and so far-reaching that it can simply smuggle in subjective policy preferences under the convenient excuse of EU withdrawal. Now, in that regard, there's no doubt whatsoever that the delegated powers that the government has proposed for itself under Clause 7 are certainly adequate to the job. They're certainly good enough to do the job. And in various respects, credit where credit is due, the government makes a persuasive case for these delegated powers to be broad and flexible. For example, the government will not give a fixed list of the particularities, we call them failures and deficiencies in the bill. It won't give a fixed list of the particularities that will need to be addressed because it doesn't want to tie its hands and find that actually in all of the nooks and crannies of our legal system there are other quite legitimate but unforeseen challenges that might have to be addressed. Similarly, the government wants these powers to last beyond withdrawal for a period of 2 years. 2 years after we leave, the government can continue to exercise these correction powers. And again, that feels reasonable, because even with the best will in the world, I doubt that they will catch everything. Things will slip through the net and will have to be dealt with urgently when they actually arise. But having said that, the delegated powers proposed under Clause 7 are not merely adequate to their task, their potential scope and depth is so extensive that they are capable of defining, let alone addressing, the problems contemplated by Clause 7 in remarkably wide-ranging and far-reaching ways. For example, the material scope of the Clause 7 powers is almost without limit. They don't just apply to the correction of retained EU law, they actually apply to any UK law whose modification might be considered appropriate in order to address deficiencies in retained EU law. So the scope of these powers is actually virtually universal. Secondly, the nature of the problem that Clause 7 seeks to deal with is expressed in very wide terms. The bill simply refers to failures of EU law to operate effectively, or any other deficiency in EU law. And the only express limit is that the government can't use these powers so as to unilaterally update UK law in the light of subsequent changes to EU law. That's obvious and right, but it's the only express limit. The nature of the solutions that the government can adopt in response to the Clause 7 failures and deficiencies are equally elastic. It can be any provision that a minister considers appropriate. It includes any provision that could be made by an Act of Parliament. It includes subdelegating these correction powers to any other body, and in fact, it includes subdelegating regulatory powers full stop to any other body. And again, the express limits are fairly narrow. They can't be used to impose taxation, to make retrospective provision, to engage in serious criminalisation, or to modify the Human Rights Act or the Northern Ireland Act. They are very limited exclusions. So even on the most narrow, and I do stress that, the most narrow interpretation of Clause 7 would empower the government across an indeterminate but potentially huge number of situations to change or terminate individual rights and obligations, to amend the criteria for or the considerations relevant to or the purpose of the exercise of a huge array of statutory powers, to substitute existing decision makers, alter their functions or change their decision-making processes, and indeed to establish entirely new regulatory standards for entire sectors where the government considers that the existing EU rules are no longer appropriate. Obviously, those powers can include extensive policy changes, that's just obvious. And yet those Clause 7 powers are capable of much broader interpretation. That was only the narrow baseline interpretation, because concepts, as any lawyer will know, concepts such as a failure to operate effectively, or a deficiency, or a causal connection which is expressed in terms of arising from, are inherently nebulous. Different decision makers can very easily reach very different conclusions about whether retained EU law might cross those thresholds, depending on essentially subjective views about what is effective, or what is successful, or what is a failure. Similarly, the government's proposed solutions don't need to be necessary, they don't need to be proportionate, they just need to be appropriate in the opinion of the minister. And so there's an inbuilt discretion for any action under Clause 7 to go far beyond the technical and into the substantive and indeed the significant. And I'll just take one example to work out these propositions, and it comes from Clause 7 itself. Clause 7 refers to a deficiency which arises where a minister considers that retained EU law makes provision for reciprocal arrangements between the UK and the EU which are no longer appropriate. Reciprocal arrangements which are no longer appropriate. What is a reciprocal arrangement for these purposes? Now, in a narrow interpretation, if we were to take a narrow view of Clause 7, we'd say purely reciprocal arrangements between public authorities based on mutual rights and obligations which can only operate on a mutual basis. For example, I ask you for information, you are legally obliged to provide it for me. Well, in the absence of a legal obligation to provide that information anymore, it's no longer reciprocal. We should delete it from the legal system because it no longer serves any useful purpose. But a wider interpretation of Clause 7, and there is evidence that this is how the government does understand the Clause 7 powers, would actually refer to a much broader category of reciprocity. It would refer to any situation in which the UK currently offers any degree of domestic legal recognition to EU products, services, goods, people, qualifications, authorisations, at the same time and under the same conditions as other member states offer a comparable degree of legal recognition to UK products, services, people, goods, qualifications, authorisations. Now, there would be nothing to stop the UK, after withdrawal, from continuing to grant legal recognition under our legal system to whatever foreign goods, products and services we want on an entirely unilateral basis and without any clear obligation of mutuality by anybody else. But equally, it will be entirely open for a government minister to take the view that if UK citizens don't get treated that way abroad, foreign people won't get treated that way here. And therefore, any form of reciprocal recognition to foreign standards or products or services or whatever shall simply cease upon withdrawal. If that is the case, it is an enormous discretionary change which will have fundamental consequences for the rights and obligations of millions of individuals. And indeed, the concept of reciprocity could go much, much further. We could say that virtually every regulatory standard enacted at the EU level is intended to promote a level playing field between the member states by reducing barriers to trade, removing distortions of competition, so as to facilitate the smooth operation of the single market. Once the UK leaves the single market and we no longer benefit from this level playing field between member states, no EU regulatory standard is reciprocal in that sense. And if we follow this interpretation, and again there is evidence that some government supporters understand Clause 7 this way, then any regulatory standard that has ever been enacted at the EU level across every imaginable sector of our economy or society would be deficient and therefore amenable to amendment, replace, whatever the government deems appropriate. Indeed, it's almost besides the point whether we even think of these problems in terms of reciprocity, bearing in mind that the Clause 7 powers are non-exhaustive, and a minister can simply say they no longer think any of these things are appropriate anyway. So the powers proposed under Clause 7 are exceptional in their potential scope. And if you think that I'm exaggerating, you just need to look at the recent reports of the House of Lords where they describe the powers as exceptional, unprecedented, breathtaking. This is the consensus view of any constitutional lawyer who has examined this bill. And it's very difficult to identify any clear dividing line between the technical and the mechanic, more sensitive policy choices, which are nevertheless inherent to the very act of withdrawal, and we accept that those are needed, and simple subjective policy preferences to change the law under the cover of withdrawal. And certainly what is absolutely clear is that the government's repeated promise that any significant policy changes would be made only through primary legislation, not by delegated powers, is meant in only the most minimal way imaginable. Primary legislation will be recommended for those sectors which effectively require outright redesign and re-regulation, customs, agriculture, trade. And otherwise, significant policy changes will be made under the bill using delegated powers. So this brings us on to our final murder mystery question. Given that these unprecedented executive powers, what are we, the citizens, what are we entitled to expect by way of effective parliamentary scrutiny and control? Now here the government has not proposed any bespoke system for parliamentary scrutiny. We're simply going to rely on the existing processes, either an affirmative resolution, which is very exceptional, it's where Parliament has to positively approve a draft government measure, or a negative resolution, which is much more common, where the onus is on Parliament to positively veto a government draft. My previous experience has led to mixed views about the effectiveness of these well-established scrutiny procedures. On the one hand, the tiny number of times that Parliament has ever actually exercised either of these powers to reject government measures might suggest that the system has never been particularly fit for purpose. On the other hand, of course, parliamentary commentators would remind us that the numbers don't really give an accurate picture because it's the very possibility of parliamentary rejection which shapes the government's thinking in advance and provides Parliament with its true power, the power of influence, rather than the power of veto. Now, without doubting that important contextual point, and I agree with it entirely, there are nevertheless reasons why we should be concerned about the effectiveness of scrutiny for this particular bill. First of all, the government has defined the range of draft measures that would require affirmative resolution by Parliament in the narrowest possible terms. Only a tiny number of the potential draft measures under this bill will require affirmative parliamentary approval. Secondly, we should bear in mind that the delegated powers under the bill are going to be exercised in truly exceptional circumstances. The sheer number of measures that are going to be required under Clause 7 alone have been estimated at well over 1,000. Many of those draft measures will be highly complex and lengthy in their own right. All of them need to be processed within excruciatingly tight timetables, and at the same time, Parliament's finite resources and energy are required for major other bills in redesigning our agriculture, our trade, our immigration, our customs, and so on. So if parliamentary scrutiny of delegated legislation is limited even at the best of times, we certainly don't think it's going to work very well in the worst of times. Now, I've discussed the proposed powers under Clause 7. As I said, you'll probably have to take my word for it that similar problems arise under the other clauses of the bill. And of course, the bill as a whole has other important facets which demand scrutiny, not least the impact on the current devolution settlements and the quite legitimate concerns expressed by the Scots and the Welsh about the impact of this bill upon their devolved competences. But I'll leave those aside. They're interesting questions, but I'll now conclude. My colleague and I at Liverpool, Dr. Mike Gordon, also a Cambridge graduate from Queen's, I think, we wrote in a recent briefing paper that the EU Withdrawal Bill simply presents the UK population with an impossible dilemma. It's an impossible dilemma from which there is and can be no satisfactory outcome. Because on the one hand, if the UK leaves the EU and wants to do so without inflicting serious disruption and uncertainty upon ourselves, we're not doing it to anybody else. If we want to avoid inflicting serious disruption and uncertainty upon ourselves, then this whole process of retention, incorporation and amendment, the core activity of this bill, is essential. On the other hand, if you judge this against other fundamental constitutional criteria, the bill is highly problematic. It's based on an extensive centralisation of power to the UK government from the devolved nations and a massive delegation of power to the UK government from Parliament. And as such, it has the clear potential to destabilise key constitutional relationships, to infringe key constitutional values, not least those relating to democracy and legitimacy. Now, is this to suggest, for 1 second, that somehow the government is actually going to engage in a conscious or systematic or widespread abuse of power? No, of course it's not. But even still, these issues, these challenges, pose two real serious questions. First, there's the principled constitutional objection. This bill is premised not upon the ex ante creation of delegated powers, which are objectively narrowly conceived, carefully delimited, effectively controlled. Instead, it's based upon asking Parliament and the public to show a remarkable degree of trust in the willingness of any government to exercise vast power ex post in a restrained, moderate and sensitive fashion. It's contestable whether in any country outside North Korea that is a legitimate premise upon which legislation of fundamental constitutional importance should be designed and implemented. Secondly, the powers proposed under the bill are so ambiguous and malleable that they would allow for reasonable decision makers to reach divergent conclusions about the very existence of problems and to hold very different views about the appropriateness of proposed solutions. And that doesn't just create the potential for broad interpretation of these proposed powers, incorporating a significant degree of discretionary assessment to pursue subjective policy preferences. Just as seriously, it risks the emergence of highly divergent approaches across different government departments, according to the civil service or ministerial agendas which those departments work under. But let's finish with one final thought, and at least it's maybe something to cheer up the lawyers in the room. We shouldn't forget that these delegated powers will be subject to limitation and scrutiny, not only as provided for under the bill, but also, of course, through the courts in accordance with our ordinary principles of administrative law, the doctrine of implied statutory purposes, weddings beyond reasonableness, legitimate expectations, and so on. And indeed, given the broad, the open texture of this drafting and its potential to change for the worse a huge array of individual rights and obligations, the potential for judicial review seems enormous. Now, the prospect of extensive litigation may well have the paradoxical effect, of course, of undermining, at least in part, the goal of legal certainty, which is meant to be the very purpose of this bill to promote. But at least it's going to keep academics like me writing, it's going to keep practitioners like you practicing, it's going to give all of us years, if not decades, of work. Because I suppose for lawyers at least, Brexit is actually the gift that we'll keep on giving until we are dead and buried in our graves. And on that happy note, I think that's about as happy as it gets these days. Thank you very much for your attention. And again, thank you very much, Roderick, for everything that you've done for all of us in our careers and in our lives. We are enormously appreciative.
It gives me enormous pleasure to thank our inaugural speaker at the Peterhouse Law Lecture, which we hope will become an annual event, for his incredibly insightful, interesting, highly topical and somewhat sobering talk. I'm sure you're all bursting with questions, and we have about 5 to 7 minutes for questions. So I will hand the floor to you.
Thank you for your lecture. My question is, to what extent do you think the Human Rights Act and the European Court of Human Rights will play some role in this judicial review that you foresee, if at all?
Yes, certainly. I'm not a human rights specialist, so I'll struggle to give you any concrete examples, but I don't think you need to be a human rights specialist to imagine the types of situations involved. Let's just take the question of immigration and the idea that the UK is going to design some new immigration system for EU nationals. And at least under the current proposals, we know these are up for negotiation, but under the government's proposals that were made in the summer of this year, there is the possibility that people who have been living here for a very considerable period of time and are entirely integrated in a personal sense into UK society could be told to leave the country. In that type of situation, the right to family life, protected under the ECHR, under the Human Rights Act, could well come into play. Of course, the difficulty arises is that if these rules are enshrined into primary legislation, and they're not matters of discretion, they're actual, the direct result of obligations imposed by primary law, because there the courts can't do anything about it. They can issue a declaration of incompatibility, they can say that government and parliament have behaved a bit naughtily, but ultimately they can't do much about it. So there is definitely scope for the principles of judicial review based on human rights protection to play a role, even a significant role, but it will be subject to parliamentary sovereignty and the fact that if these things are done directly mandated by Parliament, then there's not much the courts can actually do about them.
Thank you, Michael, for a really interesting lecture. I had 2 questions. Firstly, is Article 50 capable of unilateral rescission or withdrawal by the UK government? And the second question, do you think that the UK government needs to trigger Article 127 of the EEA Treaty in order to withdraw from the single market?
Okay, very good questions. Thank you. Is Article 50 revocable, and can it be done unilaterally? The only people in the world who still believe that Article 50 is not revocable are the people who don't want it to be revocable. Everybody else in the world agrees that if the UK were to change its mind, and not for abusive purposes, as in, oh, we want to revoke it because these negotiations are going terribly, and then 24 hours later, we're going to hand in our notice again, and we've got another 2 years, hooray. As long as you're not using it abusively, everybody agrees that it can be done. The only real question is whether you need the agreement of certain other players in the system or whether you can do it in a genuinely unilateral way. Now, both the European Parliament and the European Commission have said publicly that they think it should be done by agreement. The problem for them is, of course, that whose agreement do they mean? Now, the European Parliament will immediately say, our agreement, of course, but in that case, you're just making law up. You know, it's not in the treaties, it's not written down anywhere. The Commission will obviously say you need their agreement, they're just making it up. Realistically, in real life, would the UK suddenly turn around one day and say, we've changed our minds, everybody, what are you going to do about it? Never. In real life, the law and the politics will be totally intermeshed. The UK will be considering it, debating it, they'll be sounding out every national capital across the EU, and we'd only do this if we knew that it was going to work, domestically and internationally. So I think the legal position is fairly clear. Yes, it's revocable. There are issues about whether that can be done unilaterally or only with agreement of others. I think, myself, it's unilateral. But in real life, this wouldn't just happen overnight. It would be a matter of negotiation and agreement in order to make it work for everybody. On the EEA, does the UK, strictly speaking, need to give notification? I think the answer is that everyone is expecting it to. Because even if the UK didn't give notification under the EEA agreement would be completely unworkable for the UK as a non-member state of the EU. Just to give one example, the obligations under the EEA agreement are defined by reference to the territories of Norway, Liechtenstein, Iceland, and the member states of the EU. What would be the point of the UK being a party to a major international agreement if the provisions of that agreement don't apply to its territory, but it still has to fulfill all of the obligations for itself? That just doesn't make any sense. So the UK theoretically could decide we're going to cling on to the EEA like a leech, but it would do us no good and it wouldn't do anyone else any good. So I think the widespread expectation is that the UK will, at the appropriate point, give notification under the EEA agreement, because it's simply unworkable if we don't. 12 months, yeah, at least 12 months. Yeah.
Thank you. Can I ask those powers under the Repeal Bill, are they time limited in any way, or would they just remain in statute books forever, and in 50 years' time the government of the day could say, we just found another bit of law that comes under this power and we're going to use this?
Okay, it's a good question. So there are different time limits which apply to different powers under the bill. So the time limit which applies to the Clause 7 powers, the ones which I talk most about, the power to sort of correct and change any law as a result of leaving the EU, would only last for 2 years after withdrawal. Well, I say after withdrawal, to be precise, 2 years after exit day. Exit day will be defined by a government minister, and exit day can be different days for different purposes. There isn't necessarily a single exit day. So the government has given itself even remarkable flexibility over just deciding when any of these powers will commence or terminate. Other powers, though, are limited to the point of exit day, whenever that happens to be. So, for example, the power to implement the Article 50 withdrawal agreement should cease with exit day. There is one point, though, which is worth flagging up. It's been raised by the House of Commons Library Research Team. It's also been highlighted by the House of Lords. The power to subdelegate powers under the bill. So a minister could say, Roderick, you can have the power to change the rules on criminal law. Those would not be subject to any time limit because they've been subdelegated to Roderick to use for the future, and they could last theoretically forever. So there are concerns that although the main delegated powers under the bill are subject to time limits, albeit of a varying nature, the ability to subdelegate lawmaking power under the bill could lead to delegated powers which themselves could last indefinitely. And if we bear in mind that that basically means the government could say, we are handing the power to create regulatory frameworks for the financial services sector to him, or we're handing powers to make new regulatory frameworks for workers' rights to her. And that becomes their responsibility to do these things. That is one of the things that the House of Lords in particular has expressed real concern about.
Thank you very much for your talk. I guess this is a slightly more political question than a legal question, but given the nature of these powers, it strikes me as though the Repeal Bill would have been an absolute gift to a Conservative government prior to the most recent election, back when things were flying high and everyone thought they were, untoppable. Does it strike you that there may be potential for a huge watering down of the powers in things like Clause 7 because of the risk that they may be handing over this very powerful gift to someone like Jeremy Corbyn sooner than they thought they might have? And I accept this is not a legal question, so I apologise.
No, it's a really good question. I think we have to bear in mind that realistically the civil servants who've been working on this bill have been doing it since the 24th of June 2016. This bill has been a long time in the making. And of course it was designed to be used by whichever government had to use it. The government has made clear political choices about this, but it is the product of a lot of civil service work. in a way, the most important amendments that we see in Parliament to the bill actually don't have a lot to do with what I've just said. Of course, there are major proposals to improve the drafting of Clause 7, to try and say that the government should only be able to propose solutions which are necessary to correct the problem, not just appropriate. The House of Lords has put forward amendments which have got quite considerable support that would say that Parliament itself should have a special sifting committee that would go through every single government proposal and determine for itself what type of scrutiny it should get. It shouldn't be for the government to tell Parliament what type of scrutiny it's going to provide. Parliament should make that decision for itself. So some of the amendments are relevant to what I've spoken about tonight, but actually some of the most important amendments are using this bill as a vehicle for other political purposes. And this is where the weakness of the government after the general election is absolutely crucial. Because probably the most important amendment is one which basically says, if you do not come back with a good deal, or if you come back with no deal at all, we're not leaving the EU. And you will have to rescind your notification, and we're staying in. Now, obviously, that is not inherent in making this bill function. It's effectively an extraneous amendment which is trying to give Parliament a stronger say over the final deal and over a final decision to leave the EU. But if that amendment makes it in, it would completely change the entire dynamic of everything which is happening in the country at the moment. That would never have been possible if Theresa May had either not called a general election or had won the general election in the way that she wanted. So the election is certainly playing huge politics with this, definitely.
I think we have time for one more question.
Professor Dougan, thank you. You paint a picture of a legislative task which is essentially Herculean. I wonder if, even with the best will in the world, and with highly functional government departments, and with Parliament operating at its maximum capacity, is it even possible? Or is there just too much to do?
Yeah. Well, we were talking a little bit about this before the lecture. And I suppose I'm not giving too much away if I say, try and talk to some civil servants working in key Whitehall departments and see what they describe about the working culture of the central civil service at the moment. I don't think I'm being completely unfair when I suggest that massive under-resourcing, massive overwork, terrible consequences for the individuals who are bearing the brunt of all of this, and a genuine fear that there is just too much to be done within the time available and the limited resources at our disposal. And you will hear words like catastrophe, pandemonium, malfunction, breakdown. They're not my words, they're words of people who I speak to, who are doing this for a living. I'm only observing it. But we've clearly set ourselves a challenge which is simply enormous for any country to undertake. There are two things about that challenge that make me feel quite angry, actually. And the first one is that anyone who was watching what was happening knew that this was going to happen. In fact, people like me predicted it 18 months ago and said, if you vote leave, this is what you're going to get, because this is inevitable. There is no other way to do it. This is inevitable. So if you vote leave, this is what you are voting for. And the second thing I think that makes me quite angry is that, you know, when you travel the country, when you talk to these hundreds of people working in every imaginable industry, you talk to, you know, thousands of civil servants working away on this, and when you think that all of the available resource and capacity of this country is being put into preventing a calamity. It's not being put into making the country better, it's not being put into improving the lives of its citizens, it's not being put into doing anything to improve our lot in life. All of our national resources are being put into preventing a calamity. And to me, that is just a terrible, terrible indictment of our political leadership. Imagine what we could have achieved if we mobilized that energy, resource, intellect, and ability to actually improve the lives of us and our fellow citizens. And all we're doing is trying not to destroy the country. What a wonderful achievement. That makes me angry. But in answer to your question, it is quite possible that this is an impossible task, not just an impossible dilemma. We'll find out. That's the good thing about Brexit. We're actually going to put these theories to the test. And that has some merit in itself, because if nothing else, if we end up teaching the world what it looks like to entrust your future to a wild risk based on fantasies, then we will have taught the world a valuable lesson at our own expense.
Please join me once again in thanking Michael Dougan, our inaugural speaker, for an enormously stimulating lecture.
Thank you very much.
I'm told that I'm under strict instruction from Roderick not to do this, but I'm going to go off script for a moment to pay personal tribute to the person that we're here to honor today. I think I speak for a lot of us when I say that Roderick defined for generations of Peterhouse lawyers not only what it meant to do law at Peterhouse, but to be at Peterhouse. As the law DOS this year, I realized that I'm stepping into not only enormous shoes, but shoes that are impossible to fill in terms of both the charm and dignity that he brought to the role, and, as you say, his capacity to spot and draw out talent. So I know you'll all join me in raising a metaphorical glass to Roderick and in putting our hands together for him and everything that he's done for the college. Speaking of raising glasses, for those of you who are joining us to raise literal glasses and are staying on for dinner, we're going to be heading to the combination room straight away, so please join us. Thank you very much once again for a wonderful evening.